Good afternoon, everyone. Welcome to another live edition of the Employment Law Q&A. My name is Alex Lucifero. I am an employment lawyer and managing partner of Samfiru Tumarkin, LLP. We are the employment lawyers in Ontario, in British Columbia, and in Alberta. And we are here to take your questions to help you resolve your workplace problems. As employment lawyers, that is what we do. All day, every day, we speak to individuals, to employees, and to employers as well, for that matter, and help them resolve their workplace problems. So if you are tuning in, if you're dealing with an issue at work, whether it's COVID related or not, we've been receiving a ton of questions about mandatory vaccination policies, about all sorts of things going on in the workplace. If you're dealing with an issue at work, if you're really struggling with a bad boss or there's been a change to your employment situation, this is the place to be. Send in your question, type in your question. You don't have to go into any huge level of detail. You don't need to name your employer. You don't have to give your full name. Ask us a question. Seek that help that you're looking for. And I promise you, I will answer your question. I will help you resolve your workplace problem. That's what we're here for the next half hour until 2:30 p.m. Eastern Standard Time. I'm coming to you from a partly cloudy Ottawa, Ontario today. A lot of what I'm going to be talking about relates to Ontario employment law, although that's also generally true across Canada and applicable across Canada. And so again, send in your questions, guys. That's what we're here for. I'm an employment lawyer. I deal with these kinds of situations all day, every day, whether it's to do with severance or temporary layoffs or changes to your pay or changes to your workplace. Now is the time to ask those questions. Let's see them come through. A couple of pieces of contact information. If you're maybe a little too shy, a little too bashful to ask your question over a live session like this, you can always email us. Completely confidential. We will not share any of your information with absolutely anyone. It's lawyer-client privileged. You can email us very easily at help@employmentlawyer.ca. The address is on the screen right now. It's help@employmentlawyer.ca. Send us a brief description of your problem, of the issue that you're dealing with at work, and I promise you someone will get back to you. And we can put you in touch very easily with an employment lawyer that will help you resolve your question or your issue. If you want to browse our website, we've got a ton of information on our website, lots of blog posts, lots of articles, lots of video clips dealing with everything under the sun when it comes to employment law. Employmentlawyer.ca is the address. Visit employmentlawyer.ca. There is a severance pay calculator. There is what we call a pocket employment lawyer that helps you deal with changes to the terms of your employment at work. We even have a questionnaire with respect to mandatory COVID vaccinations and try and point you in the right direction, that is, when it comes to mandatory COVID vaccination policies. It's the hot topic in employment law now. I'm sure we'll get to it in the next little while. But again, employmentlawyer.ca is the website. Help@employmentlawyer.ca is the email address. That's where you can reach us if you can't reach us right now. Send us an email or visit our website, and please get in touch if you're dealing with an issue at work. All of that out of the way, guys, let's get to the meat of why we're here today, which is to help you resolve your workplace issue. And Muggsy is first here to ask their question. And Muggsy asked, we were mandated to get vaccinated fully by October 12th or be placed on a LOA, leave of absence, without pay until we comply. How is this legal? 4 question marks. Exactly. I thought it was 5 question marks. It's 4. Muggsy, that is the big question of the day and of the month. And I imagine it's going to be continuing to be a hot topic in the workplace into the future. The answer really depends. It depends on, at least if you're in Canada, it depends on how your employment is regulated. Are you a federally regulated workplace? Meaning, does your workplace come under federal jurisdiction and therefore the Canada Labor Code? or are you provincially regulated? Now, most employees are provincially regulated, meaning it's the specific provincial legislation and rules that apply to that particular workplace. I can tell you, Muggsy, that for most provincial jurisdictions, an employer cannot mandate the vaccine. They cannot force an employee to be vaccinated. At the federal level, however, it's going to be different. The federal government in Canada has announced plans to effectively require employees of federally regulated employers to be vaccinated or otherwise risk their jobs. So if you work for an airline, or if you work for a transportation company that's federally regulated, or potentially, and this is not the case yet, but it seems to be the case, that the federal government will say if you work for a bank or a telecommunications company, you may ultimately be required to be vaccinated or have an exemption to that rule, either a medical exemption or a religious exemption. But again, I want to remind all of you listening right now that most employees are provincially regulated, and under provincial rules, as things stand right now in Ontario, an employer cannot force you to be vaccinated. If they terminate your employment as a result of not being vaccinated, or if they place you on an unpaid leave of absence because you're not vaccinated, that is a termination. You are owed severance in a case like that. There's no question about that. So for any employees out there who are losing their jobs because they're not vaccinated, make sure you contact us right away. Do not sign anything. Do not accept any offers from your employer. You are owed severance. You might be owed as much as 2 years of severance. If you are also placed on an unpaid leave of absence, that's also a termination in actions rather than words outright. But that's still considered what we call a constructive dismissal, i.e. a termination, and you would be owed severance in that case as well. Before you respond to your employer, before you do anything, you want to make sure you get legal advice in a situation like that. If you are unsure about the situation at all, Muggsy, give us a call, send us an email at help@employmentlawyer.ca, and we will be in touch, and we will be able to resolve your workplace problems. It's, again, the hot button topic of the day. People should be receiving employment advice. If you're being forced to be vaccinated by your employer, before you do anything, before you answer yay or nay to your employer, you want to get legal advice from an employment lawyer. So give us a call. All right, Anna asked, before I get to Anna, a question from Colin comes through. I'm trying to go in order here, guys, and I'll make it fast because lots of questions are coming through, and that's great to see. Please, guys, keep answering your questions, or please asking your questions, rather. I will make sure to answer all of them before the end of the segment today. Colin asks, is it legal for my employer to require me to get a rapid test weekly because I don't have the vaccine? Ottawa, Ontario, FYI. Excellent question, Colin. And the short answer is yes. There have been a number of cases that have gone through, at least in the unionized context, various arbitrations and decisions already with respect specifically to COVID-19 and testing. And for the most part, and I would say every case that I've seen, testing has been deemed legal and required in a lot of workplaces as a health and safety measure. So, Colin, to answer your question, yes, if you are not vaccinated and your employer is not going to let you go for that reason, which they shouldn't, by the way, then they can require you to be subject to mandatory testing. Now, if that's on a weekly basis, then that's fine. It has to be reasonable, and your employer should be footing the bill for that testing. But weekly testing is going to be deemed legitimate and reasonable. All right, Anna, let's get to you. My husband got injured and put on WorkSafe BC. I imagine that's some sort of workers' compensation. Anna, and I'm not in BC, so my advice might be limited here. He's been almost a year now in vocational rehab. He will not get the vaccination. What are his rights? Should either the school or WorkSafe BC try to push vaccination requirements to attend? It's an excellent question, Anna. I have to say I don't know the specific requirements in BC when it comes to whether the provincial government has mandated vaccines. But that is the answer to your question. If it is the provincial government that is requiring either the school or employers to employ to employ vaccinated individuals, your husband might not have any recourse against the school itself or the workplace itself, because again, the employer can't take responsibility there. They are simply following what the government is telling them to do. Now, if the government hasn't implemented a mandatory vaccination policy, either for the school or for the workplace, then your husband might have some options there. I can't speak to the school necessarily. It's not our area of expertise. But certainly when it comes to his employment, again, the employer shouldn't be terminating him based on his vaccination status. But your husband might be forced into a practical difficulty, which is he's going to have to choose between either being terminated and receiving a severance package or getting vaccinated and keeping his job. It's a very difficult spot, don't get me wrong, but the practical reality of the matter is it might come down to that option for him. So, Anna, we have an office in Vancouver. We have lawyers licensed in British Columbia that can help you answer exactly these questions. Please send us an email at help@employmentlawyer.ca or find our contact information online on our website. And certainly one of our lawyers in BC can assist in more detail. Do not be shy to reach out. If there's ever a time to receive legal advice when it comes to these mandatory vaccination policies, the time is now. Abdul asks, if I have a religious exemption and it's denied, what can I do? I am in a union. Great question, Abdul. Your religious exemption shouldn't be denied if it's a legitimate one. And what I mean by that is, if you're going to claim a religious exemption, Abdul, you should have something from a local religious leader confirming your position. It doesn't have to be in any huge level of detail. We don't need to know anyone's history within that religious organization or how religious they are or aren't. All of that is nonsense. But you do want something from someone local and from someone who holds themselves out as a religious leader, in a legitimate way, and you want a brief letter from that person confirming that this is a religious belief that you follow. If you provide that to your employer, if you're able to get that, Abdul, and provide that to your employer, they shouldn't deny it. And quite frankly, they can't deny it on those grounds. If they do, that's potentially a human rights violation, and it's also potentially a constructive dismissal. Now, Abdul, because you're in a union, you can only pursue those kinds of claims through the grievance process. So if you are able to get a letter from a religious leader confirming that it's a legitimately held religious belief, and they still deny the exemption, speak to your union about it. Your union has to file a grievance. It's not an ideal solution, but as a unionized employee, it's the only solution you have. It's one of the drawbacks, unfortunately, from being unionized. Great name here. Dill Pickle asks, my pregnant wife is facing being let go from her administration job at a local hospital over vaccine mandate as of September 22nd. Any advice? This is in Ontario. Dill Pickle, the same situation applies to your wife as I just went through previously, which is that unless your wife can potentially, because she's pregnant, get a medical exemption. And listen, I don't pretend to be a doctor here. I have absolutely no idea whether that's legitimate or not. But really, the only two exceptions possible are a religious exemption or a medical exemption. If you can get something from a doctor or from a religious leader confirming that you shouldn't be vaccinated, your employer has to accommodate you. They can't let you go under one of those two circumstances. If that doesn't apply to your wife, then she has a practical problem. The problem is either she get vaccinated or she risk losing her job. I want to be clear that if she does lose her job, she would be owed definitely severance and potentially additional damages based on the termination and the fact that she might have been terminated because of her medical status, given the fact that she's non-vaccinated. But again, we're talking severance there, and we're talking damages, effectively a monetary compensation. There's nothing we can do, or any employment lawyer for that matter can do at the time, in order to save her job. And again, this becomes a practical problem. So think about those exceptions, especially a medical one. If your wife is pregnant, there might be a conversation worth having there with her doctor. And if that's not the case, she has a decision to make. All right, Will asks, I'm still employed and my job is asking for either a medical or religious exemption. What do I do? And what What if while I'm trying, I don't get an exemption? I am not in a union. Will, again, if you've been listening, and I hope you've been listening, the same rules apply. Your employer should be providing you with some reasonable amount of time to get an exemption. If either it's a medical exemption and you have to make an appointment with your doctor, well, listen, you can't get into your doctor's office that same day. Sometimes you have to make appointments weeks in advance, and that needs to be respected. And otherwise, if it's a religious exemption, well, then, again, some reasonable amount of time, maybe it's a couple of days, maybe it's a week, needs to be provided. Again, I have to come down to this, guys. If you're not going to get something from a doctor or a religious leader, you're going to have to practically make the choice of either keeping your job or being terminated. That's what it's going to come down to. I don't agree necessarily with that situation. I think there's something fundamentally wrong with an employer forcing an employee to get vaccinated. But as things stand right now, if an employer wants to end your employment, they can, provided, of course, the correct amount of severance is paid. If there are any more questions or concerns in this respect, and I've answered this question a couple of times now, guys, so I think I might start skipping over the mandatory COVID vaccine questions at this point in time. Happy to answer any other questions you have that are employment law related. covidrights.ca is a great resource. The website was just on the screen there, covidrights.ca. Again, we've got a ton of information, a ton of articles, a Q&A with respect to any employment issues related to COVID-19. If you're looking for some guidance, if you're looking for a starting point with respect to your issues, that's the place to go. Listen, I'm more than happy to answer any COVID-related questions when it comes to the workplace and employment law as well. But I don't want to keep repeating myself with respect to those particular questions. And so I'll move on to a different topic, guys. Let's see here. Lots of questions about COVID vaccine. Dill Pickle follows up. She's going to talk to her doctor next week. We'll be in touch if any other questions. Thanks for doing the Q&A. No problem, Dill Pickle. That's great. I think that's the starting point. Speaking to her doctor about it. Again, I don't know what the medical advice is going to be, but certainly you want to be having that conversation with your doctor. Brian asks, EI is telling me I must get sick benefits as I need accommodation for an injury. That is correct, Brian, and at least that's the initial starting point. Unless your employer has a short-term disability benefits plan that's kind of an internal plan within the company, so sick days or something along those lines, you can probably access that first. But if your employer doesn't have sick days or doesn't have an internal short-term disability plan, then yes, before you apply for long-term disability benefits or even short-term disability benefits under an insurance policy, you will have to go on what employment insurance calls sickness benefits. Sickness benefits last for, I believe, 15 weeks, if I'm not mistaken. It's something in that range, and you do have to be enrolled in that. Unfortunately, the downside of that is that it's not going to be your full compensation. If you're making a good income, then it might be significantly less, because it might only be about $500 every 2 weeks. But that is unfortunately part of the process when it comes to a disability leave, and particularly when it comes to something like long-term disability benefits. Any disability insurance policy will have a term in it that says you have to access the EI sickness benefits first. And there is effectively a waiting period before you can start receiving disability insurance. So unfortunately, Brian, that's what it's got to be. And if you have any questions when it comes to either the disability insurance side of things or how your employer is treating your disability leave, your medical leave of absence, do make sure to be in touch. We field those kinds of questions all day, every day, and it's important to get legal advice in a situation like that. All right, guys, let's keep it moving here. Still lots of questions about the mandatory vaccination policies. And, again, I'm more than happy to answer those questions. I've already answered a few of them with respect to choosing between getting vaccinated or being let go from your employment. And I don't want to repeat myself too much here because I'm sure most of our viewers have already heard my advice. But for those of you listening in and are new on the live chat, I'll say it one more time. The problem is more a practical one than a legal one. Practically speaking, if your employer is asking you to be vaccinated or terminating your employment as a result, it may come down to choosing between those two things. Now, if your employment is terminated because you're unvaccinated, again, you're definitely owed severance. You might even be owed more than severance. That might be a human rights claim because you've been terminated on the basis of your vaccination status. But there's not much we can do at the moment, or anyone can do at the moment, to save your job. If you want to save your job, then you're going to have to fall under one of these two exemptions, which is a medical or a religious exemption. If that's not the case, and you continue to choose to be unvaccinated, you're going to be looking at a severance package. And certainly, if your employment is terminated because of your vaccination status, you need to speak with an employment lawyer right away. Don't sign off on any severance documents. Don't sign off on anything for that matter before you speak to an employment lawyer. If your employment is going to have to come to an end for that reason, you want to make sure that you're getting as much as possible out of your employer in the form of severance and in the form of compensation. So do be sure to be in touch if your employment comes to an end, or alternatively, and what we're seeing lots of as well, is employees being placed on unpaid leaves of absence. You're effectively being sent home without pay as a result of your vaccination status. That might be an out-and-out termination as well. It depends on what industry you find yourself in, depends on whether you're unionized or not as well. But again, the starting point is reach out to us. Someone will get in touch with you. And if we can be of assistance, we will certainly let you know. All right, Bruce asks, and I love the questions, guys. Please keep them coming in. We've got about 8 minutes left here, and I'd love to help as many people as possible with respect to any issues they're dealing with in the workplace, whether it's COVID related or not. If you have a question about severance, if you have a question about temporary layoffs like Bruce does, please ask. Now's the time. We've got about 7 minutes now or so left. Bruce asks, my employment contract does have a provision for temporary layoff, but even if they ever go through with that, it eventually becomes dismissal, right? When in Ontario, ? That's correct, Bruce. If your employment contract has a provision with respect to temporary layoffs, that may allow an employer to temporarily lay you off. Now, temporary layoffs are not indefinite. They can't last forever. There are some pretty set limitations on how long temporary layoffs can last. One point that I'll make, Bruce, just because your employment contract has a temporary layoff clause, it doesn't necessarily mean that it's enforceable. If your employer is going to temporarily lay you off, you want to receive legal advice right as it happens. Don't wait until later on in the layoff period. Speak to one of our employment lawyers right now. Depending on the circumstances around when you sign that contract and the language of the contract, whether the language is enforceable or not, these employment contracts have to be very, very carefully worded. And so a lot of employment contracts that we see are unenforceable for one reason or another. And so even though that language exists, or even though severance language exists in an employment contract, it's not a guarantee that it's enforceable. And certainly in your situation, Bruce, if you're ever laid off, don't just assume that the contract applies. Make sure you get legal advice. And yes, you're correct. It's not indefinite layoffs. For example, layoffs right now that are related to COVID, what they are calling infectious disease emergency leaves, are scheduled to end on September 25th, so in just a couple of weeks. Now, again, that doesn't, I'm assuming there that those layoffs are legitimate, maybe because somebody has something in their contract that allows that. Keep in mind that as a starting point, temporary layoffs are not legitimate unless they're written into your employment contract, or unless temporary layoffs are a term of your employment. Maybe you're a seasonal employee that's laid off every season, every winter. That might be a term of your employment. But otherwise, an employer doesn't have the automatic right to temporary layoff their employees. So anybody who's being laid off at this point in time, they should be receiving legal advice. Chances are a temporary layoff is illegal. And so you want to make sure that you speak with an employment lawyer and know what's what in your specific circumstances. All right. Lynette asks, how do you prove religious beliefs? I alluded to this before, Lynette, which is the best way to do it is you want a brief letter or a brief note from a local religious leader, whether that's a priest or anyone else for that matter. You want it to be local. You want it to be a religious leader that you have a relationship with, and a brief letter from them confirming the religious belief and confirming that you are a member of that particular religion. That is ideal. An employer really can't say anything in response to something like that, so that is the ideal way to claim a religious exemption. Seplums asks, I plan to retire in April 2020. I want to give 6 months notice. Can they let me go before April? I have 30 years with this company. Great question, Seplums. The answer is, well, yes, they can likely let you go before, once you've given your notice, they can let you go before that. They would have to respect the notice that you gave, meaning they cannot, it's either one of two things. Either they would have to continue your pay for that 6-month period and make sure that you're made whole for that amount of time that you're now being unemployed for. In other words, they can't let you go within your resignation period and just cut you off without pay. They'd have to respect the fact that you were going to be working until April. Alternatively, and perhaps even better, Seplums, if they let you go before that period, you might be owed your full severance entitlements, which as a 30-year employee might be very significant. So, this is a delicate situation. If you haven't announced your retirement yet, and you suspect that your employer might be letting you go, from a financial point of view, it might be better to actually let you go. You would be owed full severance based on 30 years of service. That might be as much as 2 years of pay. So you might want to judge the situation and ultimately decide to either provide less notice of a retirement or extend potentially your retirement date into the future, but don't jump the gun and retire. If you feel like you might be let go, you might be sacrificing your severance entitlements. Again, it's another one of these situations where you might want to speak to an employment lawyer first before you make any decision. Now, if you've already announced the retirement and you formally submitted your retirement date and you are let go, then at the very least they should be paying you up until that retirement date, and you should also have service. Especially if you have a defined a defined benefits pension plan, your service date should be the your last day of service should be April 2022, not the day they let you go. Again, any questions or any concerns in this respect, it's a very particular, very delicate situation. You want to reach out to us and get some advice in a situation like that. All right, Bruce follows up. I struck out the line where my employer tries to take away my common law reasonable notice before I sign the contract. That's excellent, Bruce. And if your employer accepted that, listen, ideally they would have initialed that paragraph as you would have. But if you struck out the line and submitted that employment contract back to the employer and the employer didn't say anything in response, that's excellent. You've preserved what we call your common law severance entitlements, or what you refer to as common law reasonable notice. That is severance based on an employee's age, position, and years of service. It's the ideal situation that you want to be in if you are let go as an employee, because those are your full severance entitlements. And as I was alluding to previously with Seplums, who had 30 years of service, that can be as much as 2 years of pay. So these common law severance entitlements are very, very significant. You don't necessarily want to sign an employment contract that limits your severance entitlements to something else. A lot of employment contracts will have language in them that says your severance entitlements, or your termination entitlements as they're called, are limited to the provincial employment standards legislation. So a lot of them will refer to, in Ontario at least, the Employment Standards Act. The same piece of legislation in other provinces will be similarly named, and you don't want an employment contract that limits you to the Employment Standards Act, because that might only be a week or two per year of service as severance entitlements. you want to preserve your full severance entitlements, which are, again, your common law severance entitlements. And in that respect, ideally, your employment contract or your offer letter says absolutely nothing about severance. That's the ideal point of view, guys. We'll have to end it there because it's 2:30. I hope I've addressed all of your questions with respect to mandatory COVID vaccinations. Join us again tomorrow, or I believe on September 15th, with my colleague Lior Samfiru at 1 p.m. Eastern Standard Time. In the meantime, if you have any questions, employmentlawyer.com or .ca, employmentlawyer.ca is our website, and we've got a ton of resources there. help@employmentlawyer.ca is the email address. Email us, guys, if you're dealing with an issue at work, whether it's termination, whether it's COVID related, whether it's a layoff, whether it's a change to the terms of your employment. help@employmentlawyer.ca is who you should be emailing, and I promise we will get back to you. It's been an excellent session today, guys. I look forward to speaking with you again. Have a good rest of the day. Have a good rest of the week and weekend, and we will catch you soon.